Hello everyone, I'm Jose Ramirez, manager at In Solidum Lawyers. I'm thrilled to have you join us for this new educational episode. Throughout our professional journey, we've observed how the law impacts every facet of our society, and one of the most significant and often misunderstood areas is administrative law. Administrative law isn't merely a set of rules and regulations. It is the bedrock that governs the relationship between the state and its citizens, ensuring that our public institutions act justly, efficiently, and transparently. Each one of us, at some point, interacts with these entities, be it renewing a license, applying for a permit, or merely exercising our rights as citizens. Today, I invite you on a journey that goes beyond mere definitions. We will delve into the fundamental principles and concepts that brings this branch of law to life, helping you understand how administrative decisions are shaped and how they impact our daily lives. I hope this session clears your doubts and piques your interest in the fascinating world of administrative law. Join me in this discussion as we explore its foundational concepts. To venture into the captivating realm of administrative law, we must start with its definition and grasp its scope both in the legal field and everyday life. When we speak of administrative law, we refer to a specialized branch of public law. It is the part of the legal system responsible for regulating the various interactions and relationships between the state, specifically the public administration and its citizens. Imagine all the times we engage with a state entity, from obtaining an ID card, applying for a building permit, to accessing a public health service. Each of those interactions is governed by administrative law. But what does this truly mean? It means there's a set of standards, regulations, and principles that dictate how state authorities and entities should act in the relationship with us, the citizens. This is crucial as it ensures the state's decisions and actions occur within a legal framework, always striving for the general welfare while respecting its individuals' fundamental rights. Furthermore, administrative law isn't static. It evolves to address society's changing challenges and needs. This is why laws are continuously created and reformed. New procedures are established and all structures are adjusted to match the present reality. In short, this area of law is essential because it provides us with security and certainty in our dealings with the public administration, set clear boundaries for our state's actions, and ensure our voices and rights as citizens are respected and protected. Administrative law holds pivotal importance in our lives, and often we might not realize its depth. Even though it might sound complex, it's deeply rooted in our daily experiences. Firstly, administrative law assures that all actions, decisions, and procedures of the public administration are framed under the law. This is no small matter. Picture a state where each entity or official could act based on their discretion without a guiding legal framework. It will be a scenario of unpredictability and potential arbitrariness. Administrative law lays the foundation and boundaries within which public administration must operate, ensuring fairness, justice, and predictability. Secondly, this branch of law safeguards our rights as citizens. Every time we request a service, file a complaint, seek a license, or merely wish to be informed about some state action, administrative law is there, ensuring our rights are respected and that we have the proper mechanisms to exercise them. Moreover, in a democratic state like ours, it's imperative to have a system that monitors and oversees administrative action. This is where administrative law plays a critical role. It provides us tools to demand accountability, challenge decisions, and ensure the public interest reigns supreme. Lastly, administrative law mirrors our evolution as a society. As societal needs, challenges, and priorities shift, administrative law adapts, laying down new legal framework and procedural norms responsive to contemporary realities. For all these reasons and more, administrative law isn't just important, it's indispensable. It acts as a compass guiding state actions and simultaneously a protective shield for our rights and interests as citizens. The relationship between administrative law and the citizenry is a dynamic and intimate one that goes beyond mere regulation. In fact, we could say that the essence of this branch of law lies in bridging the gap between the state and its citizens. To begin with, administrative law ensures that the public services each one of us uses, whether directly or indirectly, meet standards of quality and efficiency. From obtaining an ID, applying for a construction permit, to appealing a traffic fine, behind each of these actions are regulations and administrative processes that seek to ensure the citizen receives fair, transparent, and efficient treatment. Moreover, this branch of law acts as a shield for citizens against potential abuses or misuses of power by the administration. If you ever feel that a state body has acted arbitrarily or unjustly, it is administrative law that provides mechanisms to appeal, challenge, or contest such decisions. For instance, if you believe a particular municipal fee is excessive or that a public service is not being provided adequately, there are established administrative procedures for citizens to lodge complaints and seek remedies. On the other hand, administrative law is not only reactive but also preventive. It helps establish controls, audits, and review systems to ensure the public administration always acts in favor of the common good and not individual interests. This proactive approach ensures transparent and responsible public management. In this sense, administrative law is more than a set of rules and procedures. It's a manifestation of the social contract between the state and its citizens. It sets the rules of the game, ensuring that the relationship between the administration and the citizenry unfold within a framework of respect, fairness, and justice. It is, in short, a vital tool that balances the power of the state with the freedoms and rights of the individual. The concept of an administrative act is central to administrative law and has profound implications for how we interact with the state. To fully grasp it, let's break it down. An administrative act, at its core, is a decision made by a state entity or authority within its competences. It's an expression of will or decision that takes on a specific form and is intended to produce legal effects. We might liken it to an official decision that has the power to affect our rights or duties as citizens. Such an expression could be the outcome of a judgment or analysis. It might be a settled acknowledgement or even a mere wish of the administration. For instance, when you apply for a driver's license and it's granted to you, the granting of that license is an administrative act. Similarly, if the administration imposes a fine for an infraction, that fine is also an administrative act. It's vital to understand that administrative acts are not isolated or inconsequential. They have direct legal consequences. This means they can affect your rights, obligations, and your legal standing in relation to public administration. And this can manifest in various ways, creating a new legal situation, like when obtaining a permit, modifying an existing one, like when renewing a document, or even ending a situation like when a contract with the state expires. Another crucial aspect is that administrative acts are bound by principles of legality and fairness. They cannot be arbitrary or contrary to the law, and if a citizen believes an administrative act is improper or unjust, they have the right to challenge it and seek a review or annulment of said act. Therefore, every time we interact with public administration and it makes a decision that affects us in some way, we are witnessing an administrative act. It is a fundamental pillar in the relationship between the citizen and the state, and its proper understanding is essential for the protection of our rights. Administrative law in Ecuador is founded on a framework of norms aimed at ensuring an efficient, transparent public administration that serves its citizens. Our primary guide is, of course, the Constitution of the Republic of Ecuador. It not only enshrines the fundamental rights of its citizens, but also establishes the limits and competences of the various state entities, ensuring their actions always promote the common good. In addition to our Constitution, in recent years we've seen significant progress with the enactment of the Administrative Organic Code, COA. This legislation consolidated and modernized various provisions that were scattered across different legal documents. The COA is crucial as it explicitly details the administrative procedure public entities must follow, thus ensuring due process and the protection of citizen rights. But it doesn't stop there. It also tackles crucial topics like the state's responsibility in its various forms and how this can be demanded, the legal status of assets under the public sector's custody, and the foundations for providing public services, ensuring their quality and continuity. All this legal framework seeks essentially to create a balance where public administration always acts with integrity, efficiency, and legality, while citizens feel protected and confident that their rights and interests will always be respected and addressed. Transparency, efficiency, and legality in administrative actions are fundamental pillars in any democracy, and Ecuador is no exception. To ensure these premises are met, our country has a system of oversight entities that, from different perspectives, supervise the state's activity. Firstly, we have the State Controller's Office. This entity plays a crucial role in auditing public management. Its work isn't limited solely to ensuring the proper use of public resources. It also oversees the administrative, financial, and operational management of all public sector entities, aiming to detect and prevent potential irregularities or acts of corruption. On the other hand, the Ombudsman's Office plays a fundamental role in protecting citizens' rights. This institution acts as a bridge between the administration and the citizens, intervening when acts that might infringe on people's rights are detected, whether committed by public actors or private ones providing public services. Additionally, we cannot forget the crucial role of the judicial system. The administrative contentions recourse, for example, is a vital tool for citizens, allowing them to challenge administrative decisions they deem harmful or contrary to the law. Through these mechanisms, judges review and, if applicable, revoke or modify administrative acts, thus ensuring respect for legal provisions and citizens' rights. These entities together create a network of oversight and supervision that ensures public actions align with general welfare and adherence to the law. The relationship between the public administration and citizens can sometimes generate tensions or disagreements. Fortunately, our legal system provides tools that allow citizens to exercise the right to defense and seek a fair solution to these conflicts. Before resorting to the judicial path, it is advisable and in many cases necessary to exhaust administrative avenues. In this regard, the Administrative Organic Code, COA, establishes various remedies that citizens can bring before the same entity that issued the disputed administrative act. The review remedy, for instance, allows individuals to request the authority to reconsider its decision. Meanwhile, the appeal remedy sees a hierarchically superior body to review and, if applicable, modify or revoke the initial decision. But these aren't the only mechanisms available. If the citizen exhausts these remedies and still believes their rights have been violated, they can turn to the administrative contentious jurisdiction. This is a specialized jurisdiction responsible for reviewing the legality and adequacy of an administrative act and has the power to annul those contrary to the legal system. It's crucial for citizens to be informed and act promptly. There are specific deadlines for filing remedies and lawsuits, and not adhering to them could result in the loss of the right to challenge. Therefore, it's always advisable to have appropriate counseling, allowing a full understanding of the rights and tools available to the administrator. At In Solidum Lawyers, we firmly believe in the importance of an empowered and informed citizen, capable of exercising their rights and ensuring a fair and transparent public administration. As we've discussed throughout this talk, administrative law is a fundamental tool in building and sustaining a democratic and just state. In regulatory framework and the entities in charge of supervising and controlling administrative actions work together to ensure that the public administration acts with transparency, efficiency, and above all, in total respect for the fundamental right for each citizen. Conflicts between the administration and citizens are often inevitable. However, it's the set of norms and procedures established in a legal framework that allows resolving these conflicts in a fair and equitable manner. Being informed and knowing the defense and challenge avenues is essential to ensure a healthy relationship between the state and its citizenry. From In Solidum Lawyers, we want to reiterate our commitment to working alongside you, advising and guiding you in this and other fields of law. If you have more concerns or require a specialized service, we are at your disposal to assist you. I deeply thank you for dedicating your time to this talk, and I hope it was to your liking and usefulness. Until next time, and take care.